Us in order to take up the second case on on today's docket. And after I call that case, as we did this morning on the first case, I will ask counsel to stand, state their appearances for the record, and then we will proceed directly to oral argument. I now call that case number 90198, State of Kansas v. Jonathan D. Carr.
May it please the court, Sarah Ellen Johnson of the Capital County Office on behalf of Jonathan Carr. Meryl Carver-Allman did the same office with her at table, and we are ready for argument.
May it please the court, Assistant District Attorney David Loudon on behalf of the state.
Kim Parker, Chief Deputy District Attorney on behalf of the state.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state.
Very well. Counsel, you may proceed.
Good afternoon, Your Honors. May it please the court. Your Honor, I would like to reserve 15 minutes for rebuttal, if I may.
15 minutes is granted.
Thank you. I would like to begin our presentation today by returning to the Batson issue that I heard being discussed this morning. I have some thoughts that I would like to contribute to that discussion. First, I would like to note that the district court's decision on the refusal to allow the strike of juror WB is not entitled to tremendous deference by this court simply because of how flawed that ruling was, how lacking in following the Batson steps that it was. As Justice Johnson pointed out earlier, it's an abuse of discretion to violate the law or not to follow the proper legal steps, and that is where we are right here. As it relates to Jonathan Carr's attempted use of a peremptory strike on juror WB, who I'd like to point out we also challenged for cause earlier, the district court didn't even wait for the state to make an official challenge to our attempted use of the strike. In fact, the district court invited the challenge from the state, turned to the state and said, "Is there a challenge?" As if to say, "I've already made up my mind, state, tell me you're challenging, and I will refuse to allow this peremptory strike."
So what is the prejudice that's suffered by the court incorrectly not allowing a peremptory challenge? We have a jury that's fair and impartial by using the strikes for cause standard or the showing for cause. What is the remedy here? I guess I asked that this morning, and I still haven't heard an answer that is satisfactory, at least in my mind.
Well, first, Your Honor, I would like to point out that we have raised an issue challenging 3 of the jurors who ultimately sat on the jury as having been improperly not excused for cause. That's in issue number 37 in a supplemental brief that we filed about a month or 2 after filing the initial brief. So we do dispute that these cause challenges were appropriately handled. So we would dispute from the outset that we have an unbiased juror. And this particular juror is one of those 3 jurors that we challenged for cause and that we maintain on direct appeal was an improper cause decision by the district court. So we have that prejudice. Further, the prejudice is having this juror that should have been allowed to strike, that we properly provided a basis for striking, that we attempted to strike, that the state didn't dispute any of our statements about what this juror's attitude in the court was. So we have an unchallenged assertion that this juror was sarcastic, was contemptuous, was dismissive of mitigation, was very pro-death penalty, and then this juror proceeded to hear the case, proceeded to, in fact, be the foreperson of the case who first found my client guilty.
Does it matter what the basis is for the challenge to excuse the juror on a peremptory? I mean, here you've articulated some reasons that you believe are race neutral, but does it matter? Let's say you just didn't like the way the juror appeared, which you have the right to do, and other than making it a race-based kind of appearance,
correct,
you can just say, I want to strike. Would you be making the same argument that you had the right to strike that juror?
Absolutely. We're entitled to 12 peremptory strikes as long as we're not engaging in racial discrimination against a particular juror, which I think is, from my understanding of Batson, that's the core of the Batson concern, is protecting individual jurors from being racially discriminated against. So in this case, where we've offered multiple reasons that have nothing to do with the race of the juror, we were entitled to use that strike. I would be making that same argument no matter what our explanation was. And I would urge this court to look to the 609 letter that we filed a couple of weeks ago, wherein we cited an Iowa Supreme Court case that came down in 2012, post-Rivera, considering what is the remedy for a reverse Batson issue like this. And that court said reversal is the remedy, because there is no other way to correct this. The problem is that that juror went into the jury room. The problem is that the district court erred in allowing that juror to be on the jury room, despite
I'm still having trouble filling in the blank. Justice Rosen's question is, the prejudice is blank. And so is the prejudice that you wanted to use your challenge and you didn't get to?
That is part of the prejudice, yes.
What else?
That juror that we did not want on the jury and we were entitled to strike participated in deliberations.
And that's what I don't understand, because if we were to disregard your striking for cause argument, then you're back to Justice Rosen's question, which is you've got your pool and they're fair and impartial. So now you've lost one. What's the prejudice from that? I can understand you had to use a peremptory, that you had to use your peremptory challenge somewhere else. But okay, and they got in the room. So a fair and impartial juror got into the room. So what?
That's the prejudice, that juror that we were entitled to strike, that we didn't want on the jury, and we struck and were entitled to strike, served on the jury. And that's what the Iowa Supreme Court found in the Moots case that I recently 609, is that the prejudice is almost unnoticeable. We can't know what exactly the prejudice is. We don't know what happened in the jury deliberations.
Let's go at it a little different way. What is the underlying purpose of a peremptory challenge? Is there a constitutional due process basis, or what is being accomplished by allowing peremptory challenges?
There's not necessarily a constitutional basis to the peremptory strikes. There is, I would argue, a due process challenge, because we have a statute that says we're entitled to these strikes, and so you do have a due process problem if they're arbitrarily denied.
In the respect that essentially it's allowed the state to pick your jurors for you, because the state can challenge your challenges?
Absolutely. The point is to allow the defendant to be a participant in jury selection and to not just be stuck with necessarily the first 12 people who walk in, but to have some say and to say, this juror seems off to me, or this juror isn't somebody that I want judging my case. I don't trust this juror. We've set up this system for who knows how many decades, allowing defendants to participate by the peremptory strike. And when one is arbitrarily denied, and that juror is made to then sit in on the deliberations, be part of the decision-making process, and in fact, not just vote for guilt, but then also vote to send my client to death row, that's the prejudice.
Ms. Johnson, you mentioned the Iowa case.
Yes.
If memory serves, since Rivera said that states could decide whether they were going to apply a harmless error kind of analysis or not to this kind of error, it's 5 and 5. 5 who say that we will apply harmlessness and 5 that say we will not. What makes the cases from jurisdictions that say we will not apply harmless error more persuasive than the others?
Whenever we're talking about what goes on in the jury room, the defendant is automatically at a disadvantage in terms of trying to establish what that prejudice is. There's no way to know how that one juror being on the jury affected the entire course of deliberations, from demeanor, from maybe that juror directed some questions, or maybe a different juror would have had entirely different questions. We can't know. We're talking about putting together 12 people, and when you take one out and put a different one in, you're going to have an entirely different dynamic. Certainly as to the penalty phase, clearly one person could have made the difference between a life verdict versus a death sentence in this case. So obviously one juror makes a tremendous difference at that stage. I would argue it makes the same difference at guilt phase. And I would also submit that there is no sound reason for applying a remedy to this issue only to penalty phase as opposed to the trial. What we stated as our reasons for wanting to dismiss this juror should not determine what the remedy is. The problem is that this juror served on the jury. What we stated in court may seem only to apply to the penalty phase, but the juror sat on the entire trial, and I'm troubled by the idea that what the defense attorney says, articulates in the heat of the Batson moment could dictate what the remedy is for this issue. I think the cleanest thing to do is to say the remedy is reversal of the trial in its totality. I would also point to the fact that a lot of social science research has suggested that death-qualified juries are more likely to err on the side of convicting. And so, yes, the death qualification process has been shown to lead to more conviction-prone juries. So in that respect, I would submit that it does make a difference at guilt phase and not just at penalty phase. If there are no further questions there, I would move on to the severance issue. I think this morning's hearing makes it somewhat clear that Jonathan Carr was in fact facing two prosecutors in that courtroom and not just one. The trouble is that the second prosecutor was his brother, and that's a pretty powerful indicator of guilt to have your brother sitting right next to you and saying, it was all him, he did it, he did it, he did it. That's a level of it's not proof, it's not evidence, but it's a very powerful factor in a courtroom to have the defendant's brother saying, it was all him. There's no way that that couldn't have affected how the jury ruled on this case, how the jury saw the evidence, the lens through which the jury considered everything. I would also point out that Reginald, throughout this trial, engaged in what I might call some antics that, again, because he's sitting right next to my client, Jonathan, sucks Jonathan in. There's the day that Reginald just decided, I'm not going to come to court. That has a negative impact on how the jury sees Jonathan, too, especially given the way that these two were treated as sort of one entity. We have Reginald being required to be in court with handcuffs on. Now, we don't know for sure that the jury saw that or didn't see that. We do know that the district court provided Reginald with something to cover the handcuffs, and Reginald declined to use that. And the district court said, well, Reginald, you're bringing any prejudice on yourself on that.
That was during the penalty phase.
That was, yes. But I would point out that the handcuffs were on during the guilt phase, and the record's simply silent as to what efforts were made to cover the handcuffs during the guilt phase. But certainly we have, during the penalty phase, the district court saying, Reginald, you brought this prejudice on yourself, and paying no mind to the fact that Jonathan had done absolutely nothing at this point. In fact, the district court said Jonathan's behavior in court has been perfectly appropriate. We also have another incident where that was put on the record where apparently Reginald scooted his chair right up to the district attorney, maybe touched her in some way, all very certainly inappropriate behavior that then Jonathan Carr's defense is prejudiced by because he's being viewed through the same lens. He's sitting right next to Reginald Carr. These things wouldn't have happened.
The behavior toward the prosecutor wasn't necessarily visible to the jury, right? We don't know that on the record.
We don't know that.
Okay.
You know, we don't have a clear record if there were other incidents. We don't know if the jury saw that. The jury was never asked, unfortunately. But those are the incidents that we know about that were put on the record. And all of this happened because Jonathan and Reginald were tried together and because we simply didn't give them each the separate trial, certainly the separate trial that Jonathan was entitled to, so that he would not be tainted by both the behavior of Reginald in the courtroom and the finger pointing by Reginald's attorneys that would never have happened.
What finger pointing did they do towards, in the guilt phase?
There
The
was,
defense was he wasn't there. How's that pointing fingers at? I
There
mean,
was-
Reginald, your defense was Reginald did it. How is that, how does Reginald's defense that he wasn't there?
there was,
Yeah, I understand what we're arguing this morning is, has potential difficulties, but what about for your client?
there was a comment, an opening statement that we objected to, moved for mistrial over, that was Reginald's defense attorneys bringing up this, it was Jonathan and some other guy. There was also the testimony through Stephanie Donnelly saying that Reginald was very angry with Jonathan that day, that morning. And in fact, even after our objection was sustained to that, defense counsel for Reginald went and had her say it again, or asked her again, so Reginald was angry at Jonathan. Those are the best examples from the record that I'm familiar with. The behavior of Reginald is a much bigger component in our severance issue
Okay.
than,
But it's not so much the antagonistic defense, it's more just the whole environment of having two co-defendants there and their siblings, and the behavior of one can be applied to the other. That's
yes.
more of it.
There were certainly antagonistic defenses. We're certainly maintaining that. And, we were denied putting on a statement that Tronda Adams heard Jonathan say that morning about what did smoke Reginald get me into. We weren't allowed to put that on. And could that have come in, at least at penalty phase, at a trial that didn't involve Reginald? And I would submit yes. So we were denied that. And we were also simply...
Let me refresh my memory on the facts on that. She overheard Jonathan say that in a telephone conversation he was having with his sister?
Correct.
And that was excluded on motion in limine by the state?
That is correct. So again, our argument is that there were antagonistic defenses and that we were prejudiced by the actual behavior of Reginald in the courtroom. And throughout all of this, I would urge the court to remember the final issue in our guilt phase brief, which is cumulative error. I don't think that's something that any of us can overlook in terms of how did all of these individual little things pile on and create a fundamentally unfair trial for Jonathan Carr. We've talked about the denial of this one juror. We've talked about the failure to sever. I've talked briefly about challenges for cause. We also have an issue where we've argued that the district court was biased in the way that the court addressed challenges for cause, granting almost every challenge for cause made by the state and denying almost every challenge for cause made by the defense, and in fact often rehabilitating the state's or the defense cause challenges and the opposite of rehabilitating the state's cause for challenges. All of these things sort of start to pile on, and we have to ask the question of, fundamentally, at the end of the day, was this a fair trial? All of these errors combine with each other, and I would urge the court not to overlook that portion of our argument. I would like to move on. I know Justice Beyer had expressed an interest in the aiding and abetting instructional issues, and we've
Counsel,
raised...
before you do that, can you address the related issue of the amount of evidence against your client if you're raising this cumulative error?
I think actually the aiding and abetting instructional problems go to the level of evidence, actually. As certainly as far as the capital murder counts go, the evidence is really, there's no fair inference from this evidence that there was anything other than one shooter. If you look at all the shots came from one gun. And if you look at the trajectory of the bullets, they all originated from the same spot. It went 1, 2, 3, 4, 5. The idea that the gun was being passed back and forth simply doesn't match up to the physical evidence, the fact that there wasn't much gap between the gunshots. There was one shooter. And The evidence is clear that
But that's an argument from the evidence, what you just said. That's not the evidence. The person who talked about the trajectory didn't say firmly only could be one shooter. We don't have that positive statement from a witness, do we?
I don't know that we need that, though. We have,
I understand you can argue inferences, but we don't have an expert on the stand saying this is a one-shooter deal.
no, but no expert would be able to say that. But it would involve, in this case, I take a shot, okay, now I step back and let you take the gun, and you take the next shot, and then you step back and I step back into that place. The trajectory does show the likelihood is that they all came from the same position.
Okay.
So no, from my view of the evidence, there really isn't a reasonable inference that there was anything other than one shooter. We know that it was all the same gun. We know it was not the gun that the eyewitness saw Jonathan with. Jonathan had the silver gun. The murder weapon was the black gun. So we have a situation where one person is the shooter and one person is not. This gets us into the aiding and abetting, and as far as the great weight of evidence towards capital murder, my position would be that we don't have clear finding by the jury that my client, Jonathan Carr, separately premeditated and intended these killings. And that's a necessary component. We don't have certainty that the jury made that finding. They were certainly instructed that they could find him guilty of crimes that were reasonably foreseeable, not even as a probable consequence of the crimes that were agreed to, just reasonably foreseeable. And that, as we know from Overstreet, Englehart, that instruction is incorrect as relates to premeditated murder. Certainly, if that's true for first-degree murder, it has to be true for capital murder. And that gets us to the position where we don't know. We don't have overwhelming evidence to declare any of these errors harmless based on the idea that it's clear that a jury would have found Jonathan Carr guilty of premeditated intentional murder had they been correctly instructed that that was the finding they had to make.
Well, the evidence of premeditation goes further than just the actual shooting itself. The evidence of premeditation starts way back when they're putting them into the vehicles, they're separating them, they have a very calculated plan, the evidence is that they're both involved. There's all kinds of evidence that points towards premeditation beginning at the house and going all the way there, and you're just focusing on the shooting itself.
Well,
And speaking of the shooting itself, address the fact that there is at least was time for whoever wasn't the shooter to object between shots and to try to stop it, as opposed to assisting by standing back and being silent.
well, of course, standing back and remaining silent isn't the same as specific premeditation. Mere presence is not sufficient. As far as all of the activities before, I would point out the Schreiber incident where the person was taken out into a field to be left there, and tires shot out so that he couldn't get back to call for help in time to catch these people. This is consistent with that, potentially.
But the eyewitness here testified that when she was first taken out in the vehicle, they hid themselves, the driver hid himself, didn't want her to look at him, but she noticed specifically that when they were driving to the field, they didn't seem to care if their identity was known, or he didn't seem to care. And that was the difference between that and the Schreiber incident, where he was not allowed to see his attacker.
Except, of course, Schreiber was able to see Reginald Carr. I don't recall any claim that Reginald was truly concealing his face when he walked up to the car initially. But I would also suggest that perhaps having...
What about the fact that there seems to be a plan between the two of them to separate these individuals and put the men in the trunk, put the women in the back of the car, drive out there, have them kneel on the ground, shoot them execution style? Isn't that all evidence of premeditation and aiding and abetting even though it's not the actual shooting.
I would argue that that is also, at least putting them in the car, separating them, driving them out to a field, is also consistent with what was done with Andrew Schreiber and leaving them out there so that they couldn't call for help immediately.
Well, to clarify, counsel, you're not arguing that insufficiency of the evidence, are you?
No.
You're arguing that the evidence was not so overwhelming that it negates the instruction error on aiding and abetting. Is that what you're arguing?
Absolutely correct. Okay. Arguing that the jury was not told that they needed to make the finding that they needed to make, and that there is at least credible evidence from which they could find reasonable doubt, at least as to premeditated intent by my client, and that, you know, they're tried with the Andrew Schreiber incident, so we know that there's a history of leaving a person in a field and trusting, you know, this is 7 days earlier and nobody's been caught for that, so perhaps they're a little more comfortable with that idea that that really will work out. But again, as Justice Johnson said, the critical problem is that the jury didn't make this fact-finding. And we do have a pretty solid basis of evidence to suggest that there really was only one shooting and that the jury really did need to make this premeditated intentional finding as it relates to both the shooter and the non-shooter, and they were not told that. They were told that they could find either defendant, Jonathan Carr, guilty based on this crime being reasonably foreseeable. And I think clearly many of us would say it could be reasonably foreseeable that you have guns and you know, engage in some of these behaviors, that a shooting is a reasonably foreseeable consequence at the end of the day. But that's separate from the jury having to find that Jonathan Carr himself formed the premeditated intent.
This argument isn't specific to your client, is it?
I think it's better for my client.
You may be the only one who made it, but it's not specific.
I would always argue that the reasonably foreseeable instruction is incorrect as relates to any premeditated intentional killing. The facts of this specific case show that the gun that was the murder weapon was not in Jonathan Carr's hands. So on a factual level, I think it's much stronger for Jonathan in this case.
Just because of the gun, who had possession of which gun?
Correct.
Well, is there also a factor in here of who was driving which vehicle?
Yes, that also plays into it, that
Jonathan, go ahead and give me the facts of that.
That Jonathan was in the truck and Reginald was in the other car.
The truck went first, didn't it, to the field?
Yes, but it was the individual in the car who got the men out of the trunk and had them kneel down. That's always been my interpretation of that testimony anyway. There are no other questions on that issue. I would like to briefly discuss the venue issue. You know, obviously those issues don't have a great track record at this court, but I would submit if this is not the case where a change of venue should have been granted, where a district court abused its discretion in failing to grant it, then there never will.
What in your mind does it take pre-voir dire, pre-jury selection to meet the presumed prejudice? Is there some kind of magic number that we should be looking at when we get these? We had a same kind of scenario last week in a case involving a rural area. This is an urban area, but the same questions came up regarding the same kind of scientific evidence.
I don't know that there can ever be a magic formula to decide this is the case, you know, these numbers are the right numbers. We have, you know, from the survey that Lisa Dahl did, we have 96% media saturation in Wichita versus a significantly lower number in the comparative study done in Wyandotte County. We have 75% fixed opinion of guilt in that survey versus I think it's 20% in Wyandotte County in that study. And I think the jury questionnaires that came through bear that out, that media saturation in Wichita was extreme, that Sedgwick County, had a hard time walking down the street and finding people who didn't know about this case. Maybe that was a little easier than walking down the street and finding somebody who didn't have a fixed opinion of guilt, but those opinions were pretty well established through this study that Lisa Dahl did, and it was corroborated by the jury questionnaires and the jury selection process.
How do you get around nearly every jurisdiction in terms of determining actual prejudice based on pretrial publicity, bases that on voir dire and bases that on questioning jurors? And in this case, there was no finding of actual prejudice based on seating a fair and impartial jury. How do you get around it? That is the test, and that is the way that to validate the scientific evidence.
Well, again, this is where I would point the court back to some of the other issues that we've raised about jury selection. That it's easy for a district court at the end of the day to say we have a fair and impartial jury when that district court is the one making all the decisions, and that district court is denying almost every single cause challenge that the defense makes and granting almost every single cause challenge that the state makes.
It's a little different question, but go ahead.
It folds into the same point. We have multiple cause challenges that we've raised on direct appeal that we feel the district court was incorrect on. And so if we already are at a point where the district court is not properly seeing biased jurors and not striking them from the jury panel, for that district court to then go on and say, well, clearly we have a fair and impartial jury, it's a self-fulfilling prophecy. The district courts...
Are you saying that it's when the court says we didn't have any problems picking a jury, that's influenced by whether the judge grants challenges for cause?
Well, I'm saying if the district court doesn't see any problems and denies every problem that the defense raises...
What about looking at it from a different standpoint? And I see your point. If you're looking at the number that were challenged for cause, we have one person that's in charge of that. But what about the number of challenges made by the defense? What are we looking at here as to how many of the jurors were challenged for cause by the defense counsel?
I don't have a percentage breakdown in my head of how many jurors were voir dired and how many were challenged for cause.
And would you say that that had any impact was impacted by the process employed?
I'm not sure I understand.
Well, you would expect defense counsel to challenge for cause regardless of whether the court was prone to granting them or not. I
would expect the defense to challenge for cause when a prospective juror has said something that warrants a challenge for cause. The challenges for cause that were made in this case are all, in my view, justifiable. In the end, we had 6 jurors on the final jury panel that the defense had challenged for cause, including juror WB. We had 2 jurors who expressed opinions of guilt and were challenged for cause on that basis and sat on the final jury. So for the district court...
I'm sorry, how many did you say you said there were 6 who had been challenged for cause?
Correct.
And how many of them were challenged for the...
Opinions of guilt, 2.
Yes, 2 of
Yes.
the 6. Okay.
Yes. The other 4 were all mitigation, impaired to pro-death penalty, which, factors into the question of a fair and impartial juror. So I guess my point to that is that we have outside evidence that shows that this jury was perhaps not as fair and impartial as the district court chose to believe it was.
Was there a point at which, is there a point when a district court judge should just disregard a prospective juror's declaration of impartiality? And when is it? If
Yes.
there is, when is it?
Yes, there is. And that's part of the presumed prejudice calculation. And there are, quotes in the brief from various cases about the idea of when you have one of these cases that involves so much media scrutiny and so much sort of hysteria in the community long before the case gets to trial, that it's asking too much of a human being. We all want to believe that we can be fair and impartial and come into the courtroom and put away everything that we've heard and think we know about the case. But in some cases, in cases like this, where there's that much media saturation, it's really asking a little too much to believe that everybody is going to be able to do that to the extent that they say they will. And that's the whole idea of the presumed prejudice analysis to a venue change, is that we can't necessitely trust all of these jurors when they say, even if they're not even well-meaning jurors.
I guess that gets back to my original question. When is that shown? By your study that shows a certain percentage based on media saturation have knowledge of the case, that's enough, and then we don't move on anymore?
No, there's more than that. There's the extensive evidence that was put on in connection to the change of venue motion relating to
which has occurred in 3 or 4 other cases, which we, not including last week's that we had, the same type of evidence, and we haven't concluded based upon that type of evidence that the presumed prejudice has been met. And what's different about this case?
This is the Carr brothers. We can't pretend that that's not what's going on here. This is a different case than I think one that the state of Kansas has seen in decades, in terms of the level of media scrutiny, in terms of the level of national attention that this case got as compared to any other, the level of focus in Wichita on this case, I think is truly unlike anything that we've seen in decades. I've certainly never seen any other case like it. So I think we have the combination of a study that has some of the highest numbers that we've ever seen in any of the change of venue cases that have come before this court. We have the media saturation. The record is filled with exhibits from both videotapes from news reports online or on TV and written news that rose even to the national level. The focus in Wichita on this case was unlike anything we've ever seen before, and I would submit if this is not the case where this court would say a district court has abused its discretion in failing to change venue, then there is no case.
But that almost strikes against you when you say, well, there was national exposure and you're going to move this someplace.
Except if the national exposure were infecting all of the rest of Kansas, we wouldn't have seen the numbers that we saw from Wyandotte County. The fact that a case makes national news is perhaps most noticeable to the people in the local community who are truly affected by it and looking for the case. And I think that's the distinction. If there are no other questions, I would submit the remaining issues on our brief, and I would respectfully ask this court to reverse Jonathan Carr's convictions.
Do we have any further questions?
Hold on just a moment, if you will. Okay, thanks.
Thank you.
Any further questions? All right, thank you, counsel. As counsel is approaching the lectern, I thought I would announce the court will take a break after his presentation and before the rebuttal by opposing counsel.
May it please the court, David Loudon, Assistant District Attorney for the state. I'd like to spend my time, if I might, just addressing some of the issues that were raised during counsel's argument. I too would submit the rest of the issues on the brief to the extent there are no questions from this court. There's been a lot of focus this morning given to the strike on WB, and as I sat through the prior argument on this, some things struck me that I think deserve attention before we get into the meat of it. Under Batson and McCollum, there's a three-part test, obviously. What concerns me is I think there were some misstatements or suggestions regarding what that test requires. The first step, obviously, is the prima facie showing by the person opposing the strike. The next one is the requirement.
And what was that here?
That here was what the law requires on the prima facie showing. It's not much, Your Honor. The law states, federal law states, that the state need only indicate whether the prospective juror is a member of a cognizable racial group, and that he was the focus of a strike.
Well, everyone would be a member of a racial...
A minority group, Your Honor. And this person was undeniably black, and he was undeniably the focus of a strike.
And it doesn't...
That meets the prima facie challenge.
And it doesn't matter what the defendant's ethnicity is.
It doesn't, Your Honor, simply because under McCollum, they recognize that you need not share or have opposing races in order to do the strike. What would be suggested by that notion is that we could never challenge successfully, for instance, a black-on-black strike. We're not here today to determine the believability of the state's reason on that prima facie showing, at least initially.
And we're not here to decide the believability of the second step either, are we?
I'd have to clarify, Your Honor, but per se, no. What is required is that there were race-neutral reasons. There was something that Justice Biles was referring to concerning whether the antagonistic why not would be a race-neutral thing, yes or no. And I would tend to focus on, look, is it race-neutral? Yes. Whether the court believes that is a separate question. Who has the burden to show that? That would be the state. The blending of the second and third steps, as is suggested by counsel...
It's not the believability, it's whether it's pretextual. Whether it's hiding a discriminatory purpose.
Well, sure, and I think there's a credibility finding of that. I mean, certainly you can't suggest that the defendant could openly... if he gives a reason and he says that I'm striking him because he's black, I mean, that's obvious and that would never fly. So there is a certain component in any reasons that are given in light of everything that's happened in the record as to whether the state or the person who's opposing the strike has met its burden. I don't think we can absolutely say, well, for instance, there's some discussion about what the court sees, if it's a sigh or a slumping down or something, as Justice Rosen, I think you pointed out, and I'm sure you've experienced this, is where the state gives a reason, I didn't like his body mannerisms. And this court is often loath to believe that because the record sometimes doesn't reflect it. But there are times in the record where the court would say, yes, I saw that. And, if it goes, and I don't think there's any quibble with affirming the court's decision if you believe something like that.
The problem we have here is we don't know, right? So do we just assume that the court made the necessary conclusions to support?
Well, interestingly enough, it was that question from you that bothered me. That was one of the things that bothered me as I listened to the other argument. The standard of review here is abuse of discretion, and there's good reason for that. It's not something we're going to pay lip service to because we disagree. One thing that we cannot discount in this case is that there was somebody in the room who was required to make sure this was a fair trial, and that was Judge Clark. Judge Clark, unlike appellate counsel of any nature, whether it be the defense or the state, had the ability to view what was going on in that trial. When the questions were being asked, watch the entire process. It's a perspective we don't have. Too often we're reading through a transcript and we're reading like it's just going like this. And well, we don't know is, was there a pause? Was there a hesitancy? Like with the antagonistic aspect of the why not. In the first case, Ms. Parker was contesting, whether it was antagonistic or not. The defense is saying it was antagonistic. To me, it doesn't matter.
What about what would we have to observe with regard to defense challenging the state's strike of the other African American? In other words, being a proponent for African Americans to be on the jury before it made this strike. There's nothing there that I can see that I need to view for that to be relevant evidence for me. Tell me what I'm missing.
Your Honor, I'm sorry. I don't want to answer your question, but I'm not quite sure what you're talking about.
You're saying that we can't view this because we weren't in the courtroom to assess it.
Okay.
Some things are simply facts, and it is a fact that the defense challenged the state's attempt to strike African American jurors.
Correct.
And we can assess what that fact means as to whether the defense was acting in a racially discriminatory manner without having viewed anyone's demeanor, can't we?
No, I don't think so, Your Honor. Again, that was another thing that the fact that we are talking about it and indicating and recognizing that there can be two sides to this situation is an indication to me that this court cannot stand in the shoes of the only court that viewed the entire process.
Is it your view then that a court's decision on a peremptory challenge when challenged for Batson is not reviewable on appeal? That's not our law.
It's not, and I'm not suggesting that at all.
So, we know we can review it. I mean, so you can't just say
Absolutely.
the appellate court is trumped because we weren't there. We get to review this.
Right.
Use of discretion. So what we have are, I think, 3 or 4 sentences from the district court that we can review for abuse of discretion.
True.
And the only thing he says is, well, I just don't, he says this cuts both ways, and I find the reasons stated, which were the reasons stated by the defense, might be supported under a certain interpretation, but they are not adequate under the law. Now, I know what the law is, and I can apply the law to what the defense counsel said. And that's what we got to wrestle with here. So I don't think we can dismiss this as saying the appellate court wasn't in the room. If you are saying it's a credibility determination, the trial court didn't tell us it was a credibility determination. It said those reasons aren't adequate under the law. And abuse of discretion, we can look at the law. So that's why everybody's having to focus on this.
Well,
we got a very thin ruling from the district court on, what's a reasonably serious issue.
I'm not going to say that I entirely agree with your concern. However, I can certainly appreciate the fact that you are. And that's why I wanted to get into the law part of this. There's been some discussion about, for instance, Justice Johnson was bringing up the prima facie thing. The law says, for instance, once one of the parties gives race-neutral reasons, the decision on whether there was a prima facie showing is irrelevant. So, you know, it concerns me that we're talking about that, especially when we did make that prima facie showing. But as we move down the spectrum, one thing that concerned me in the first instance was the third step itself. The third step does not require the state to say anything or do anything before the judge makes the ruling. The judge is the ultimate arbiter, and I recognize the weakness here because the judge doesn't say anything. But one thing the law does say as well is the judge is not required to state anything, state any reason that would be sufficient. And I would challenge this court in many circumstances after you've reviewed everything. How satisfied would you be if the court just mentioned one thing? Yes, he was slumping. I'm going to, you know, for instance, not slumping, that wouldn't be a good one, but what does he have to say to satisfy this court outside of the entire record? And I would submit, like many other abuse of discretion type situations, we look at the entire record to see if there's anything that would support it. In this case, the state submits that there are 3 other jurors who had that, and I recognize maybe that's not binding, but it is something.
Let me tell you the concern I'm having.
Okay.
It's when the trial court says, after the defendant has made their race-neutral reasons, the trial court says those reasons aren't adequate under the law. And I thought you had the burden of proof on on this challenge. And so how can anything they do be, you know, inadequate? Because you got to carry the day, not them. And the only thing you've said is, I object. You didn't even give a reason.
That's not true. That's not true, Your Honor. 2 things. I will recognize that Judge Clark's terminology may not have been the best terminology. In reading that statement, you're also reading something into it that may or may not be there. I think there are 2 interpretations, at least 2, as to what he was saying. And the thing, as we noted before, is we're hanging our hat on his express determination before the Batson challenges started, a recognition of the Bolden case, a recognition in that case that got remanded because the judge merged the second and third steps. So you have a judge here who's told you that he's read the very case that got reversed and it has the test. He's asked the attorneys if they've read that case, in which I think, I don't believe they had, but nobody was working under the impression that they misunderstood what the test was. I understand that this isn't controlling, but it means something. In this heated arena that we had at trial, this court has seen that the attorneys were not shy about complaining when they thought there was an injustice. When the court makes his strikes all the way from Angela, or one of the first Hispanic juror, I want to use her name, the first Hispanic juror, and all the way through. There are some times when Judge Clark has said some things or done some things, but the bottom line is, throughout all that, the attorneys didn't complain that the judge was somehow putting the burden where it didn't belong. This court should know from its time on the bench and the cases that it's done, oftentimes, you know, that prima facie showing may get blurred a little bit to where, you know, there would be objection. And then the next thing you know, out of the prosecutor's mouth, for instance, they would start blurting out the reasons without any, you know, affirmative showing about whether this person was Hispanic or black or whatever it may be. And then when it's done, the judge will just simply make a ruling. The fact that it's difficult to make a ruling is not an indication that the court somehow abuses discretion when there was no requirement whatsoever that it specify every reason used. And so that's why I say when we look at the record, this record isn't devoid of reasons for why the judge would do that. We've provided this court in our brief with those reasons, which include, and I don't think you can ignore this simply because it was used as a prima facie reason, and that was there are 2 blacks left on the jury, and they're trying to strike one of them. Okay, that was enough to trigger an inquiry by the court. Okay, if that's all we had, along with everything else the judge saw, that is enough for the court to say the state has met its burden of making this strike.
But is that what the judge said? That's the problem I have. When he says that the reason the defendants gave wasn't sufficient under the law, what is he saying? Was he saying that it was pretextual, which would be a fact determination, not a determination based on what the law is?
Well, I suppose, Your Honor, I mean, we could put that context into any other abuse of discretion situation. The court isn't required to give reasons for a lot of its rulings, and we search the record for that, and what we have is here for this court is a record.
And so our determination is that it was pretextual? I mean, is that ultimately the conclusion we have to say, is that he didn't abuse his discretion in saying that the reasons given by the defendant were pretextual?
I think that's the inquiry. I mean, we're looking to
And what in
determine
the
whether he made a
record would
mistake.
suggest that it was pretextual?
The fact that he is trying to strike one of two black people left on the jury.
But after he's been arguing that we need to keep black people on the
And sure,
jury.
and you're entitled to give the weight to that, and I don't blame you as you're looking for it. I mean, again, you know, I can't say that I looked at this issue and went, man, this is a dead bang winner for the state because of what's there, but what we have to consider, and that's why I'm encouraging you to look at the abuse of discretion standard and give some credence at least that this person was actually in the room. I mean, we are presuming that, or presuming away, I suppose, every benefit the court or the large amount of discretion that we give to trial courts by suggesting that somehow he has worked. I think the theme here is that the court was biased against this entire process, and his sole goal was to make sure that this person got death, and I don't think the record bears that out whatsoever.
I don't think anybody's arguing that, counsel.
Well, I think that's the theme of their brief, Your Honor, that he was slighted against him. He made for-cause challenges against their position, an inordinate amount, unfairly, is what they're arguing. And they're doing the same thing here with regard to this Batson challenge. So
I read much of the argument to be more that Judge Clark was focused on trying to ensure that there was a somewhat racially diverse jury, and that he may have put more emphasis on that than he should have.
Well, that's part of their argument, but the other part is that the judge, and maybe bias is not a great word, maybe the judge committed misconduct because he didn't apply the right test. That's part of their argument as well.
And that's an abuse of discretion.
And that's not.
That would be an abuse of discretion if he applied the wrong test. I
It
can't
is, right.
argue with that.
Applying the wrong legal standard. I thought
Absolutely.
That was my understanding, that was the
In part.
main argument.
And so I
Not that
think
he
to
had
that
some
extent, his
personal
motive could have been good, but it just could have backfired.
Oh, I'm sorry. Can you say that first part again?
I think his motive might have been good. I mean, his motive to try to retain some diversity on the jury.
Quite possibly. I don't know. I don't know that was his reason. I think we're reading that into that. I suppose that's my point.
But that's our difficulty too, is we just don't know. And as I kind of pointed out in the other situation, a lot of times when we don't know, when we don't have the factual findings that allow us as an appellate court to make an informed review, what we do is we remand and ask the court to make those findings so that we then know what the judge's thought process was. But we now really can't do that, can we? Given the situation we have. That,
It would be difficult.
yeah, so how do we deal with that?
And that's why I submit, I suppose, I'm aware of any case, Your Honor, that would say that when we stand up to make a Batson challenge and our reason is that there are two there and they're taking one away and we believe it's because, inherently, because they're a minority. I'm at a loss to understand why that isn't enough if the court believes it. We did not see, as believable as we may think the attorney's reasons are, they're undoubtedly race neutral. I mean, we can't argue that part.
Why were there only two left? The state had struck, by that point, an African American.
That is
and I'm
true.
having a little trouble saying that the prosecutor can strike African Americans down to the place where there's only two, and when the defense tries to strike one, say, oh, that's discriminatory. When you say your reason was there were only two left, That's because you had, or your office had struck other African Americans, or at least one. Correct?
Again,
Well, is that factually correct?
that is factually correct, Your Honor. Again, I think my difficulty with this is the person who was in charge of assessing the credibility of an argument like that, or even theirs that said, how could we possibly have been motivated by race? I'm black, he's black. We try to prevent you from taking a black off. Okay, so we had two parties, each of which would presume to be arguing the same point against one another, and we trusted somebody to make that decision, and that decision was made by Judge Clark.
We have to presume he made that decision. What he verbalized was making the decision with regard to his belief as to the adequacy of the race-neutral reasons. That's what he verbalized. To get to where you are, we have to presume the judge internally made that third step because he didn't verbalize it.
What I hear the court saying is that there, I mean, if the law at the time was the judge didn't have to say any particular words, this court is now looking to change that law.
What we're looking at is the words he did say. And the words he did say were legally incorrect because the court does not make a determination of whether the race-neutral reasons are adequate reasons or are adequate under the law. It determines whether they are, in fact, race-neutral, and then it moves on to the third step.
Of course, and you understand my argument is that language was not an indication, because in order to do that, you would have to disregard the fact that moments before that, the judge said he knew what the test was based on Bolden. Again, I am not saying that this is the clearest record in the world on this. However, it's hard for me to ignore that the people in the room weren't questioning whether the judge was making the right, using the right test to make the strike. I mean, they never complained about it. And it's on a cold record alone that everybody is now attacking that, and I understand that part of the discomfort is the fact that there isn't any verbalization from him, but and perhaps, you know, two wrongs don't make a right, but this isn't the first time in this court's history that we've bypassed that and looked at the record itself, because we allow appellate counsel to come in, review the record, and give us situations where there are other jurors who shared the same characteristics, and this court would look at that and say, you know what, the court did abuse its discretion. So, Justice Luker, I mean, if you're asking for how do you determine whether there's an abuse when there's an absence of any other evidence, and here we don't have that absence. Perhaps if there had been not had those three people that was struck, maybe the court wouldn't have that basis. But I don't know how we presume that the court was actually blind to everything that was going on. And I know that, you know, we're here potentially to decide whether the court was required to say anything. I would submit that this court has never held that. There isn't any court that has held that I know of any substance.
Could I move you to the, if we disagree and decide that it was an abuse of discretion, what's the remedy? And I'll tell you, I'm having a little problem saying that if they were passed for cause, then it's harmless. Otherwise, there's no way that we could ever enforce the right to peremptories.
Is this related to the question that Justice Rosen was asking?
Well, if we disagree with you, what are we going to do with this? We've already determined that it's not practical to remand it.
Well, the state's position, I mean, would be primarily as to whether we maintain the convictions and the death penalty would be that if this isn't a constitutional issue, Your Honor, the United States Supreme Court quite clearly has said that the right to peremptory challenges is not a constitutional issue. And as Justice Breyer has pointed out, the states are free to formulate their own test. I would submit that we don't need to do that in a vacuum. As indicated in our brief, I'm sorry, and the statute escapes me, but there's a statute that indicates what the rights are, and the rights are to 12 peremptory challenges. It doesn't indicate how or when. The reality is in any jury trial is that you're never guaranteed 12 people you like, but you're entitled to 12 impartial. You may want to strike every one that's left on the jury, and they want you to presume in this case.
You're saying it wasn't error. It's not a trial error if the court erroneously disallows a peremptory strike, because you just have no right to which ones you have 12 strikes, but you don't get to choose.
I think that you have to make an additional showing of actual prejudice of some sort. They're asking you,
and that's where I'm getting to, and we talked about that earlier. How do you show prejudice? And what's the test for prejudice? That's part of what we're struggling with, I think.
Admittedly, I can understand why. But I think that's why I'd like to take you to it's almost like we're trying to answer the question before we're trying to determine the root or the basis that would allow you to even get to the question. Here, I would submit that in order to determine if there's any remedy that needs to be employed, you need to determine what that right is. And we would submit that the right is to 12 strikes, and they received it because they had the ability to challenge for cause. And granted, in this case, they're making an argument that kind of clouds the issue. It's not like a singular issue where they tried to make a peremptory strike against somebody they didn't challenge for cause. Here they tried to challenge him for cause and for peremptory. But if we start with that starting point is that they get 12 as long as the person has been passed for cause, then there isn't a situation where you can presume prejudice, which I think is almost like the structural, to me that's related to structural error. Why is it that we reverse cases automatically on structural error? It's because we are incapable of measuring the prejudice, and that's what they're asking you here. And I would submit that in order to find that, you have to find prejudice. Here, the statute doesn't give you that ability, and neither does the Constitution. And as to the for cause aspect of it, I think that's a different question. I would submit that you would go to the for cause issue first when you're deciding this. Was that a good denial of the for cause strike? I don't think you can answer the peremptory without first answering that question. If the starting point is that the for cause strike was good, or the decision not to allow it was good, then your starting point for this issue has changed.
I'm smiling because I'm recalling some cases where this court has said, well, there's no prejudice because the defendant could have used his peremptory challenge to get rid of the juror that the for cause challenge was denied. And now you're saying, well, that's there's
If the for cause has
not on point, Your Honor. If that issue had been raised, perhaps the argument would have been different. As you know, we deal with the arguments as we take them.
I understand, but you're saying you really don't have a right, he wouldn't have had a right under the statute to strike that particular person, because you're saying that the right to strike 12 is numerical, not
Qualitative.
That's correct.
Yeah.
That's my argument.
Yeah.
And again, it's something that this court is, if this issue turns on that, that's great, and that's my argument on that. I hope that answers Justice Rosen's question, and I think Justice Biles was coming in on that too. And I suppose, if we don't win that part, the next question or answer would be that we would look to have, because he was being challenged as a death-qualified juror, we would ask that you uphold the convictions, and if you need to reverse the death sentence, then that would be the other remedy, I suppose, that would be,
And that would be based on the observations that the reasons given was specific to the death penalty and his demeanor towards that and nothing else, and therefore the guilt phase would have nothing to do with the death penalty.
absolutely.
That's your basis for that.
Yes.
As a last resort, I would suspect.
Yes, I would prefer to have them all, everything.
That would be consistent with the reasons given for the peremptory challenge as well by defense counsel. When they stated their race-neutral reasons, they talked about that this particular juror was impaired on the mitigation factors, which of course wouldn't enter into it.
Right. Just one observation, I think. I'm not saying that this controls the issue or anything of that nature, but, in this case, WB was one of 3 jurors that they're complaining about on the for-cause issue. DR and DGE are the other 2. Part of the makeup of the jury, the defendant used 8 of 12 peremptory strikes to strike some of the jurors who weren't even challenged for cause. So some of the people that they viewed, if believed, that these were the worst of the worst because you made a for-cause strike on them, I believe 4, I don't want to misstate that, but there was a number in there, around 4, that were still on the jury that weren't even challenged by the jury. It could have been 5.
4 of the 27 the state talks about who were passed for cause by both sides.
Well, I'm talking about that actually made it to the jury. There's some that weren't challenged.
Right, but I think, if I'm remembering the numbers.
I don't want to misstate that.
There's a lot of numbers flying back
I know,
and forth,
that's
but.
part of my problem as I
But
stand
as I
here.
recall, the state took the position in its briefs, there were 27 who were passed for cause by both sides. And you're saying that at least 4 of those ended up serving on the jury.
Right, there would have been 60, and out of those 60, there were 27 that everybody agreed were passed for cause.
Right.
That's your question. That's what you're commenting, right?
And they used, excuse me, I think I misstated, so they ended up using peremptories to strike 4 of those 27 who were passed for cause?
Your Honor, if I can
Sure.
get this right, can I?
Yeah, I'd like you to get it right. I'd like to understand it.
I believe our assertion on that, Your Honor, is at least in Reginald's case, on page 230 of Reginald's brief, it says, as to defendant's argument that 3 of the 4 jurors at issue remained on the panel because he was required to use peremptory challenges to remove other jurors who should have been removed for cause, Reginald discusses the use of 8 of his 12 peremptory challenges and 5 of Jonathan's 12 peremptory challenges. No mention is made of why Reginald did not use his other 4 peremptory challenges on the jurors in question, and I think there's, that would mean that there were 7.
Okay, thank you.
But again, that doesn't necessarily control the issue, but, this strike on WB as well was, it was the 12th strike. So there were 11 more people, you can either read it into it or not read it into it, but there are 11 more people they chose to strike for some other reason that seemed to be more important to them.
That's not true. When you're going through your strikes, you leave the ones to the end that you think the state might possibly strike.
That would be one way to look at it, and I'm not, like I said, I'm not saying that my version's correct, but that's one way we can look at it as we argue about this. Obviously, we're at a point where we're discussing this and having some differences of opinion, but to me, that this comes down to the abuse of discretion standard.
I want to change subjects
Thank
on
you.
you, which I'm sure you
Yeah,
want to
I'm
do
ready.
at this point.
Ready.
I need to move you over to the Walenta killing.
Okay.
Really, what's the evidence against Jonathan Carr on the felony murder?
On the Walenta killing? It's tied to the fact that he had the light-colored Honda-type car, which ended up being a Toyota car, was used. Jonathan and Reginald were known to be together frequently, and in fact, that night there was testimony that they were seen together. There's also evidence regarding the gun being the same gun used that they'd been in possession of. He had been in possession of at various times.
When you say the same one used, you mean in the other two instances?
In the other two instances.
Okay.
Admittedly, it's not quite as strong as it is with Reginald because we don't have the identification type, and that's subject to argument as well.
Can I confirm my understanding of one fact related to this question?
Okay.
As I recall it, the law enforcement officer who handled the photo ID with Ms. Walenta, it was the same person who testified that she saw the car waiting and pulling away as the shooter ran away. I mean, that seemed like the only piece of evidence that actually put a second person involved. Was that car leaving as he was running toward it or running away?
Anna Kelly is one of the witnesses. Are you referring to?
No, actually, I'm talking about law enforcement. I thought it was Reynolds or something like that. I'm sure.
Oh,
Sorry,
whether
the name
that was the only evidence tying?
Yeah, that put a second perpetrator at that crime, so if we've got trouble with, if we've got Crawford trouble with the ID, do we also have Crawford trouble with that piece of evidence, putting a second person there, a second perpetrator?
If that was the only evidence.
I don't think the neighbor talked about that. I think it was just
that
Crawford.
evidence also came in through Detective Landwehr, unobjected, I believe.
Okay, thanks.
I can verify that in just a
That would
moment.
still be Ms. Walenta talking to Detective Landwehr, correct? So we'd still have a Crawford issue potentially?
Except
If you only have law enforcement talking about a second perpetrator, that's what I'm trying to get at, then you've got the same testimonial hearsay problem you have potentially.
That's correct, except, again, we are submitting that he has to make an objection, even under the rules of evidence, and I do want to talk about that point because I don't think that the automatic review rule would apply to that count. 214627, the automatic review rule, quite clearly limits this more liberal review to convictions that also have the death sentence with it. So even though we have the same trial, I'm not sure how we graft this more open review rule to that felony murder itself.
But the problem is you're using that incident also for some of the other charges, aren't you? You're using the two prior charges to sort of set up the capital cases.
Not directly, Your Honor.
Well,
Not directly.
Indirectly. Let me just ask it in the abstract. Where there are capital and non-capital counts in the same trial,
right?
How do you divorce the use of evidence on the non-capital from the capital counts? I know the jury said, well, you have to decide each count on its own, but the evidence bleeds over. To me, it seems like that's really impossible to compartmentalize that evidence.
I suppose the best answer I could give to that is the evidence of those other crimes were not used directly to convict in the capital case. It was more of a almost like chain of custody type argument. How do we know, they are tied to the gun, for instance? And to answer your question directly, I can't say that there was absolutely no purpose, but it wasn't direct evidence of that nature. If defense counsel wanted to limit that or something, I don't see how this rule, just in general, I think my opposition to the notion that this statute on liberal appeal issues negates the necessity to object when there could be some reason for it. Admittedly, in this case, I don't know what that would be, but I don't know. I hate to speculate about why an attorney who is open and liberally objected on numerous occasions chooses not to in some other occasions. Without knowing why he didn't object, I don't know how we presume that the entry of that evidence was error. Even though we might struggle to determine at this point what that is, I don't know why on appeal that we need to jump to that conclusion. We do have other avenues to reach that in 1507. I think the limit on this new issue or unlitigated issue being raised on appeal or discussed on doesn't necessarily require this court to reach finality on any issue, but it does require this court to at least look at it and make a determination if there's a factual basis to reach the ruling itself. They can't just raise some ruling. I would submit that this court surely can appreciate that. If there's an insufficient factual basis to support a legal issue, as it always has, says, look, we're not going to take this up for the first time on appeal. Creating a situational advantage to the state on any issue can't be tolerated in the name of bringing the issue up when there's other facts that could be involved. And what we have here is I don't know what those other facts are.
I'm sorry, I'm not following that bit of argument, which...
Okay, well, let's just
it might be. I mean, Crawford, if memory serves me correct, is a 2004 case, isn't it?
Yes.
And so what we have here is a trial in 2000 or 2001. I don't know that the Crawford issue would have been raised as it's so crystallized in 2004 for us from that point forward. But back then, maybe it wasn't so crystal clear about what type of evidence comes in.
And that would be true. Well, I mean, I think the simplest example would be, why do we not take up every claim of ineffective assistance of counsel that's raised on appeal? It's because we don't know why counsel did what they did.
Right, we need facts.
We need facts, whether we do a Van Cleve or whatever it may be.
And so I'm just trying to understand how this is relating to what we were talking about a moment ago. So you're saying that that's...
I'll tell you
Okay,
why.
will you connect them up for me? Thank you.
I'm not necessarily saying on this issue. I just launched off on a tangent regarding many of the issues in this case.
That's
I
reassuring
would
to me at
encourage
this
this
point.
court, while I have my time, to, at every point that they're trying to raise a new issue that we don't get to, I just want to be clear that I don't think that that's a reason that we launch into every issue. I think this court can make a determination as to whether there's something else lurking there and that this issue can be raised sometime in the future.
Oh, I see what you're saying. Okay, thank you.
With regard to this issue in particular, though, again, my submission is that I don't know why counsel didn't object. And for this court to somehow determine that counsel erred by not objecting and that it's automatically going to take up this issue, I think that requires this court to presume that counsel made a mistake, and that determination has not been made.
What is the purpose then of the statute that says we can consider unassigned error? I believe is the language.
Well, for I'll try. I actually had this thought out at one point in time before I started working on both cases together. Now that's blurred, but there are times in the two briefs that an issue's been raised and we haven't objected when it's brought up for the first time on appeal. And if it's something that's clear on the record. Let's take, for instance, if there's a stipulation or something that's been made, and you know, for some reason, appellate counsel decides that they want to.
Well, I don't really care what counsel does. The statute says the court can consider unassigned error.
Okay.
And so what is the purpose of that allows us to look at the record and identify errors that have not been identified?
My example would remain the same, except that let's just take appellate counsel out of the mix. If this court reviews something and it's the legal propriety of a jury instructions, in fact, we do that all the time. So we determine if it's clearly erroneous. If this court reviews the record and determines that there's some insufficient instruction, this court doesn't need to rely on anything else to determine that issue necessarily. It just so happens that, you know, if that's the case and there is no dispute about the facts that would support a particular legal ruling by this court for the first time on appeal, then I don't see that would be the purpose of that statute. But I don't think that statute stands for the proposition that you can take up every issue and make a ruling on that issue. I mean, that doesn't make any sense to me when the factual basis isn't established. And we may disagree that in this case, regarding the failure to object, maybe you know, you may find that there isn't any basis he could possibly have. I would just submit my argument is that there's no basis to make that ruling.
Mr. Loudon?
Yes, ma'am.
This morning, we visited with your colleague from the DA's office about the charges on which the defendants have said there was a legal insufficiency. The rape charges as to the victim men.
The cause.
Right, and the, I'm sorry, the cause?
The cause elements causing so-and-so.
Yes, we talked about those three charges that had to do with the men as victims of rape.
Okay.
And we also talked about the digital penetration count. And Ms. Parker and Justice Johnson had a fairly extended colloquy on that. I just wanted to give you an opportunity to address those issues if you wanted to. How are those charges legally sufficient?
And if I recall the conversation correctly, and it seemed like maybe Justice Johnson didn't get an answer to his question. Is that correct, Your Honor?
I just wanted to give you another opportunity to
If
talk
I'm
about
thinking about the same one.
the innocent agent
Where the
discussion.
innocent agent could be a victim, is that right?
Right, right. Who's the innocent agent? Let's start there. Let's start at the building blocks. In the rape situation, where there's a male victim, and he is the victim because that's clearly identified, I think, in the charge. Is that person also the innocent agent, or is the female the innocent agent? I'm just trying to understand.
I'm not trying to obstruct or skirt this. Are we presuming?
Well,
I mean, there's a number of claims regarding that instruction, so that's why I'm
I'm
pausing.
just trying to focus on the legal sufficiency of a charge of rape when the perpetrator is the person who forces, through threat of force or fear, forces a man to engage in sex with a woman. And so, the man is listed as the victim.
Okay, well,
It's important,
are we going off the instructions that were given? Is that the
Well, actually, I was
baseline?
talking about the charges, the way the charge is constructed. Maybe you can help out here.
Yeah, the
In the
defendant
complaint.
is charged with raping a male, okay? That's what it says. The defendant, who is a male, is charged with raping a male.
Okay.
That's what it says. Okay, and we were trying to figure out how that can happen. And the argument in the brief was, the doctrine of innocent agent. And the complaint says that the male committed an act of sexual intercourse with the female. That's what it says. It's the basis of the charge. And so the innocent agent doctrine says the defendant can only be guilty under that doctrine if the defendant's acts would make that defendant a principal if he had done the acts. Okay? And so how I can see that if it's charged that the defendant raped the female, utilizing or forcing the male, but I don't understand how that results in a rape of the male, the way it's worded.
And your question to me is a pure sufficiency question.
It's a legal question. How can this
Okay.
defendant be legally
Okay.
charged with raping this male under the way it's worded?
Okay.
Using the male to rape himself, basically is what it says.
Well, first of all, I think that you're focusing on only part of what was charged, because the other part of that charge would be whoever that male is was forced to have intercourse without consent under force or fear. You're making an argument based on the construction of the sentence itself, and I'm not saying that because basically you're saying the charge is that Jonathan caused male to have intercourse with female, right? And you would not be asking me this question if it said Jonathan caused female to have intercourse with this male.
I'd have a different question.
Yeah, but that's the root of your issue. I would submit, Your Honor, that I don't know that there's a distinction when the entire document is looked at between the two ways that you say. You know, it's clear through the consent or force or fear aspect that he is the victim. Whether he's in the first position or the second position in the cause aspect of that, he still remains part of the sexual intercourse. Whether he's the victim or the innocent agent, he is caused to do this.
Is he both? I mean, that's what I was trying to figure out. Can the innocent agent be the victim too?
Well,
That's really what you're...
can I parallel, if I might, I'll parallel this to something else, and maybe this brings clarity, maybe it confuses the issue. If I have somebody that I want to kill, and I have a gun, I can pretty much shoot them myself or not shoot them. Instead of making that choice, I allow the victim to make the choice. I hand them some poison pills or something and say, you can either die by the pill or I can shoot you in the head and kill you. The victim decides to take the pill and die. In that instance, innocent agent and
victim. Okay.
Why is this any different? I don't know. And again, I don't know that would
Is
be
it the definition of rape that makes it different?
You know, quite frankly, I think part of again,
Or maybe
that's
it
why I was
doesn't.
asking so many questions to start with.
Yeah.
This is charged in a way that we are not accustomed to seeing with the cause language. And part of my argument on that, and that's why I don't agree that we necessarily charge male as the innocent agent in the construction of the sentence itself. But I'm also saying I don't know that it matters based upon the murder theory there.
My second question, if you're using the female as the innocent agent, how do you get around the Doyen case that says that I think that's the case, that said that in order to apply that principle, the defendant would have had to be found guilty as a principal if he'd have committed the same acts, and that's physically impossible for him to have committed the same acts.
As the female?
As the innocent.
Are you talking about
the case says that for a person to be found guilty for the acts of an innocent agent, the person must have been amenable to being found guilty as the principal if he or she had done the acts that the innocent agent did. Now, that's our case law.
That's true.
And how does that apply? How do you factor that into this scenario? Part of the reason we have it a little different is that we have males and we have females, and rape is defined in terms of the female anatomy.
Right, so your question goes to how can the defendant who has a penis put his place himself in the place of the woman who has the vagina, is what you're asking.
Under our
Some
law,
rules.
I mean,
Excuse me, may I just... Thank you, Your Honor. Counsel's reminded me, I mean, the definition of sexual intercourse doesn't, it's the penetration of a female sex organ by any object or whatnot. I think from a technical standpoint, I mean, I don't have an answer to your scenario because obviously the anatomical differences I can't account for between the two, but...
and we have the rule of lenity, and we have the rule of vagueness, that a person needs to be given fair warning of what's criminal conduct. And I'm just having trouble how anyone would understand this theory of prosecution and your theory that you're giving today based on how the complaint's worded.
Okay. I guess in that respect, I would argue that the rule of lenity doesn't necessarily apply here because we're not looking at, for instance, a construction of statute or something. I think the actions of the parties up to this point in time indicate there was no confusion regarding how this was going to be. They just didn't agree with that it was a crime.
I think we need to construe the rape statute to see if the conduct that you're alleging would fit within that definition of the crime, just like we would have to construe the murder statute to determine whether aiding and abetting a suicide in your scenario was also murder.
Well, if we... The rape statute indicates rape is sexual intercourse, and it goes on. It doesn't use the words cause, engaged, or whatever, or had, or whatnot. Again, I can't help but think that the wording that we used has caused some of the confusion, but would we be here today if we had just said Jonathan had intercourse with male victim, and then the defense, asked for a bill of particulars or however, or maybe we put into the instruction to wit caused such and such to have sex with such and such. And again, that's why I'm asking, if this is going to the sufficiency of the cause issue, if we can assert in a rape whether one person be caused to have another intercourse with somebody else, my discussion is completely different, and I guess that's the source of my confusion, and I'm standing for you. I'm not trying to avoid your question. I would very much like to answer that question. I just don't see how, when we're asserting that somebody was forced to have intercourse against their will, that this issue turns on the rule of lenity and whether somebody had a penis or whether somebody had a vagina, when it's irrelevant to the ultimate conclusion. Did Reginald force one of the males to have intercourse against his will by force or fear? And I think that as a notice instrument, that was satisfied in this case.
That's not the question.
Okay.
The question is, if that happened, and we're assuming that did happen, does that constitute the crime of rape?
If what happened?
Just what you described.
Yes. And again, that goes to their claim that because aggravated criminal sodomy and other sexual offenses have the cause language. Is this going to what you're talking about, Your Honor, as far as if it is a crime in fact, or are you just speaking on how it was actually charged with the innocent agent and victim?
Both. And you're saying that causation, if you cause someone else to do something, then you have committed that crime on the person you caused to do it. That's what you're saying.
Yes.
Okay.
Because there is the innocent agent in subsection 3 of the aiding and abetting statute. I mean, I don't know how we avoid this or how we get around the application of this. We basically have to find in any instance, with the murder one being a prime example, that because every statute that doesn't talk about cause, there are more that don't talk about cause than the ones that do. So everyone that doesn't talk about it, that we can't have a situation where somebody hides behind the actions of an innocent agent to commit the crime. I mean, that is an untenable position, I think, and I don't know how we get there.
No, I think that's you make an excellent point. And if the charge was using that innocent agent to rape the female, that's the scenario that's anticipated by the innocent agent doctrine, that he utilized the male to rape the female.
Okay.
But what you're using it for is he forced the male to engage in this act, and therefore he raped the male. Now that's what you're charging.
Your Honor, I don't want to misspeak, but if the instruction in this case, and I don't recall what the information or complaint that you're talking about is, but to reach the conclusion you've reached would be to disregard the other portion of that, Your Honor. The statute merely says that, and perhaps your hang-up, maybe if I think about it this way, maybe I can understand your question. You're saying that there's no indication that HG was forced to have intercourse with one of these males. Okay, if that's not it.
No, we're not saying that.
If that's,
It's okay. I think we've kind of gotten to impasse, and probably it's best to move on.
Right.
Did you have anything further on that? I don't mean to cut you off, but.
The only other thing I had in that regard is I noticed that it was charged in the alternative, rape or aggravated sodomy, and it referred back to some instructions. Was there any allegations of aggravated sodomy?
with regard to the males, Your Honor?
Well, anyone.
With regard to,
There are 3 counts of ag
there were
sodomy.
3 regarding the male and 1 with the female. Yes,
Okay.
with the female, there was an aggravated criminal sodomy.
Okay.
With regard to the males, no, there was not. If in that vein, I know where you're going with that. State v. Wright. If that's what that's designed to ferret out, I would ask this court to. I know Justice Moritz authored a concurring opinion in a case last year. George Lowell Brown asked that the members of this court who did not join in that concurrence join in that concurrence in this instance. It's basically a situation where there was absolutely no allegation or evidence that the men were victim of aggravated criminal sodomy. The fact that that crime was included in the instruction itself that went to the jury is essentially, I don't want to say harmless error, that's not what Griffin found, but it's a situation where there's no reasonable probability if we presume that the jury followed the instructions. And I think that's a recurring theme here is we have to presume the jury followed the instructions, that there's any basis to question whether that was the underlying sexual offense. There is no question. That couldn't have been the underlying sexual offense with regard to the capital murders of the males.
Counsel, I see you're well out of time. Would you like 60 seconds to wrap up, or do you think you've made your points?
Yes, I would, Your Honor. Thank you. With regard to Jonathan, the evidence is overwhelming in this case. You know, I don't want to use this as a complete fallback position and say that no matter what happened in this case, you know, that's not my first argument, that, you know, we can do whatever we want. There can be as much error in this case as we want, and this harmless error cures it. I think that it does, but my primary argument is that in this case, the allegations of error are not founded. And to the extent that they are, I think there's a difference between looking at error, you know, for instance, the reversal of the multiplicity arguments those don't factor into a cumulative error analysis to determine whether somebody's received a fair trial. I would ask this court to look closely at those issues to determine what truly went into the calculus there. But I do think that the overwhelming evidence, no matter when you retry this case, if you retry this case, again, the outcome will be the same because I think the evidence was that strong here. So,
Do we have any further questions of counsel?
Yeah, I need to clarify. Were you saying that with respect to cumulative error, that if there was error found and it was remedied, like reversing the convictions on the multiplicity, then that is not part of the equation for finding cumulative error? Is that what you're saying?
Yes, Your Honor, because it didn't affect other parts of the trial, we would submit.
If they're discrete, solvable problems on appeal.
Absolutely, yes.
Any further questions? Thank you,
Thank you for
counsel.
your time.
As I announced earlier, at this time, the court will be in recess for 15 minutes.
Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. This court, from recess, now sitting.
Thank you. Please be seated. Prepared to hear 15 minutes of rebuttal that was reserved.
May it please the court, I just have a few quick points that I would like to make. First, I know I didn't talk at all about the Ann Walenta case. I would note the state is relying on a harmless error kind of analysis to her confrontation clause statements based on the idea that we missed an objection. I would note that defense counsel had made multiple objections prior to that point and had been granted continuing objections to any hearsay statements from Ann Walenta. And that's in volume 102 at pages 39 and at pages 55 and 56. There comes a point where once you have a continuing objection, you've made it known to the court that you object to this testimony coming in. The district court has said, I understand your objection, I'm letting it in, you have a continuing objection. How many more objections do we need to make?
Was there a confrontation clause objection, or were those just hearsay objections?
I recall them on the record, like at the trial, as being made as hearsay objections. I would point out that this was pre-Crawford,
Yes.
so they were in a different confrontation clause world than we recognize today. And I would certainly suggest that this court, both under the doctrine that if you're on appeal when a new case comes out, that you can apply that case. And so since we didn't have the framework of testimonial versus non-testimonial, we didn't have any of that understanding at the time of this trial, that we can still apply the Crawford analysis to the Ann Walenta statements. And of course, the specific Kansas statute that authorizes this court to look at unobjected to issues for the first time on appeal.
Would you address your opponent's argument that that only applies to those counts that are death eligible, which wouldn't apply in this case?
I think it's problematic to parse through a trial of this magnitude, which specific evidence goes to only the capital murder cases, which specific evidence might be brought forward at the capital trial. The purpose of that statutory rule is to codify, if you will, the Eighth Amendment reliability requirements that go into a death sentence. And to me, everything that happens then at a death penalty trial, especially one that results in capital murder convictions and a death sentence, we have that problem of, did this in some way factor into any part of the capital murder decision? Did it factor at all into the death sentence decision? I think it's problematic to say we're going to parse out which parts of the trial get that extra scrutiny and which parts don't, when the entire trial results in a capital murder conviction and a death sentence. That would be my answer to that, that everything factors in.
We can look it up, but as it pertains, you said there were continuing objections, and I think that was to the officer's testimony regarding out-of-court statements. But what about, was there an objection to the husband's testimony, Don Walenta's?
No, the first objection that was made was to Anna Kelly, and that's at page 39 of volume 102, and that was a continuing objection. Next comes Officer Joshua Lewis at
And there
page
was an objection
50.
there.
And it was a continuing objection to any hearsay statements of Ann Walenta. So certainly the purpose of the contemporaneous objection rule, which is to give the district court the opportunity to reconsider the issue, the district court had that opportunity. The district court clearly made its ruling that Ann Walenta's hearsay statements can come in. We made multiple objections. We were granted continuing objections to Ann Walenta's hearsay statements. My argument then is that that is sufficient for the contemporaneous objection rule. I would like to return with my last few minutes to the remedy for the Batson issue. I continue to be troubled by the suggestion that the remedy can be exclusive to the penalty phase, simply because of the explanation that we gave for why we didn't want this particular juror on the jury. Certainly Beck v. Alabama cautions us not to stop only at looking at what goes into the penalty decision, but says that the reliability requirements of the Eighth Amendment take into consideration what happened at the guilt phase trial. That is part of how we know that we have a reliable Eighth Amendment ruling, a reliable death sentence, a conviction, and a death sentence that we can feel comfortable with comporting with the Eighth Amendment. If we parse out a remedy to a jury selection issue and say that really only affects a penalty because you said you really only worried about how this guy viewed the death penalty, that troubles me. We're not properly remedying that problem, which is that Jonathan Carr was made to sit and be judged by this individual that he wanted to strike from the jury, was entitled to strike from the jury, and was erroneously disallowed from striking from the jury. The remedy has to go to the entire error and not just to the penalty phase. That would be our argument. In summation, I would respectfully request that Jonathan Carr's convictions and, of course, his sentence be reversed and that he be remanded for a new trial, separate and apart from his brother Reginald.
Do we have any further questions of counsel? And I see no further presentation.
No.
All right, thank you, counsel.
Thank you.
Thank all counsel for your arguments this afternoon. The court will take this matter under advisement. At this time, court is adjourned.